Two recent legal cases in Singapore suggest that future malpractice claims might start leading to bigger payouts, which could drive up insurance premiums for doctors. To talk about this, we have Melvin C. of Dentons Rodyk and Mike Griffiths of Howden Group. Melvin and Mike, where do you think is the whole malpractice claim scene heading?
Well, I think that the malpractice scene in Singapore is becoming increasingly challenging, especially for medical malpractice. And the reason is this. During the pandemic, the number of consultations as well as procedures carried out by doctors took a dip. And with fewer consultations and procedures, there obviously would be a lower number of claims based on the probability, right, of errors occurring. So with the uptick in consultations and procedures following the end of the pandemic, we do see anecdotally an increasing trend in the number of claims being made.
We do, yeah. The experience with Howden's malpractice portfolio is reflected what was just described. So, following the end of the COVID restrictions, clinics opening up again, we've definitely seen a significant increase this year, in particular, in the number of claim notifications from our doctors. But it's more of a question of volume rather than of severity. We're not seeing any great uptick in the mega claims, if you like, but definitely there's a greater frequency of claims coming through.
With that, how might rising malpractice claims influence insurance premiums for doctors and healthcare facilities?
Okay, so at the moment, there's nothing that is drastic enough for us to be concerned that premiums are going to rise. As was mentioned, the experience for malpractice during the period of COVID restrictions was very favorable. There were relatively few claims simply because there were relatively few people attending clinics. So what we're seeing now is a correction, a return to normality, if you like. But if this trend continues, it would eventually become an issue. But for the present, I don't think there's any meaningful pressure on premium rates.
Well, I think since Mike's from the underwriting business, I think he would have the best visibility on this. Speaking as a layperson to the trade, I would have thought that with increasing claims notifications, there would be some upward pressure on premiums because with every claim, even if it is without merit, it would still need to be looked at and defended by lawyers on behalf of the doctors before leading to a resolution. And so with the uptick, we would have thought that there would be some increased defense costs incurred and therefore a higher pressure on premiums.
Now let me go to a specific issue. How does the Nur Alam counterclaim against Glen Eagles Hospital alleging paralysis due to a doctor's negligence challenge the concept of hospital liability for independent doctors?
Well, I won't say too much about the Nur Alam case in particular because this case is already in the courts. And so I do not want to say anything that might prejudice the hearing of the case. But what I will just mention is really the legal concepts involved. I think all of us understand the idea of vicarious liability, which is where an employer may be found liable for the negligence of its employees. So as you've mentioned, says, how does that apply to an independent doctor who is not an employee? So that's one legal concept. Now, the other legal concept is that of the non-delegable duty of care. And this is one where even if someone engages an independent contractor, they are nonetheless still liable for negligence because this is a duty that they've taken upon themselves. There are several established categories in law where the courts have in the past said that this is a duty that you cannot delegate away. The hospital and independent doctor scenario is not one such established category. So I think everyone in the industry certainly will be looking at the Noor Alam case with interest.
The situation in the Noor Alam case, of course, is that Mr. Alam patient alleges that he was injured through the care he received from his doctors, but he's in fact bringing his claim in part against the hospital where he was treated as well. We have in the past had claims involving Howden doctors where such claims have also been brought, alleging the hospital was vicariously liable for the actions of the doctors because the doctor had been held out as an employee or in a employee-like relationship. To date, the insurers for the individual doctors have been prepared to accept those claims 100%, even though part of the allegation was against the hospital. Now, in the case of the Alam claim, the amount involved is very substantial, and so it'll be an interesting test to see if the insurers for the individual doctors are prepared to shoulder any potential liability 100% themselves, or if they will indeed look to the hospital to contribute in respect of the claim.
And given all the recent events, what do you think is next for malpractice claims within Singapore?
From our point of view, the trend that we are seeing at the moment is an increasing number of malpractice claims that on the face of it don't appear to have a great deal of merit, but which have been brought in cases where the patient is under financial pressure in trying to meet the medical bills. So for us, the increasing cost of healthcare itself is leading to a rise in allegations of malpractice where patients simply find themselves in difficulty trying to meet the cost of care.
That's a very interesting observation that Mike has made, and I think that it allows us to cast, and give us a chance to cast a new look at some of the claims that we've been receiving, a fresh eye on those. But in terms of changes to the landscape, I think that on my part, I don't see any really broad changes to the landscape. I think one of the things that perhaps that we might want to keep an eye on is on the use of the Singapore actual tables in the assessment of damages. In a recent High Court decision, the court there indicated its willingness to consider giving a discount to the amount of damages assessed under the tables. And so this is the first judgment of Singapore High Court that has articulated this in some detail. And so I think that may help in some way ameliorate any increase in damages that we are fearing.
Thank you so much for joining us today, Melvin and Mike.
Thank you for having us.
Once again, those were Melvin C., Deputy Head of Dentons Rodyk's Litigation and Dispute Resolution Department, and Mike Griffiths, Regional Director for Healthcare at Howden Group. For more news, visit insuranceasia.com.